to the, that were made to the wind ordinance, the wind law.
Yeah, exactly. I'm sorry.
So, are we done on that subject? Who's disqualified, who's not? We probably should be
Item 5 would be one.
yourself.
You want us to leave?
No.
No.
But I just want to make sure, and if anyone else is listening, who is disqualified, who's not? Right?
Yeah.
Why
So I'm recusing myself, yes.
Okay.
Jason, why are you disqualified?
Father. So,
Why are you disqualified?
because I'm a participant,
He's a leaseholder.
You are a leaseholder?
Yeah.
I didn't know you were a leaseholder.
wasn't,
Anyway.
how we got tied in.
Oh, my sister.
And I've never been a leaseholder, so.
Your sister's married to a leaseholder, that makes you disqualified?
According to technicality, yes.
So, just to let people know, you guys decided to stay in the room and you're gonna continue to sit in the center room.
There's nobody else here related to somebody who's a leaseholder? You're not related to somebody? How can you not be related to somebody that has a lease?
You tell me.
When you grew up here, you gotta be related to
So
somebody.
third marriage doesn't count, it's gotta be blood or?
I never heard of
I
that.
still don't have anybody.
He is not a leaseholder, and he's disqualified.
It's
Who's making that
the
determination?
state. It's
The state makes this determination?
Because it can look from the public point of view that they're helping the family get what they want.
Pardon me? All right. I tell you, this is closed to the public. Am I correct in that?
Yeah.
Well,
It was, it was listed as closed.
Scott Burnside is here. He's part of the public.
It's close to the public in here, or they can listen on the phone.
They can listen on the phone. It's close to the public.
It's a public meeting.
Aren't these guys still citizens that aren't participating?
You're saying it's not a public meeting?
Pardon me?
It is a
It
public.
just doesn't make sense that
That they
they're not
have to leave.
participating, that they can't sit here just like someone that
Right.
isn't participating. It makes no
I don't
sense
have
at
a
all.
problem with you guys staying at the meeting and
I don't
listening.
think anyone's saying that they can.
No, you're
A
public,
very citizen, I mean,
you're a very citizen.
Yeah, I agree with that, but maybe it's better if we don't. You don't want to hang around.
I don't want it to look like we're influencing the rest of them.
I'll leave.
I think Mr. Burnside should leave with us.
Absolutely.
I agree.
It's not a
Closed to the
public
public.
meeting.
Right.
It's on the website, it's not a public meeting.
And we are having, it is videotaped tonight as well, so.
Is that gonna be put on somewhere that we can watch that then?
Facebook, I believe.
Is it live right now?
No, it's not live. Mrs. Naka deals with that. I send her the footage.
I'd like to, where's the video from the last town board meeting?
I have it on this drive. It's online too.
No, not the public hearing for the budget, the public meeting. The 4th, was it the 4th, Sean? No, when was that? The 11th.
October
Is that what this one is?
14th.
No, this is from the
The last one you
the
were,
last one. Yeah.
the one before.
Right.
You should leave too.
Sean's
Okay, that's what you need. I don't have
Conflict of
that.
interest, you're behind next time.
Okay,
All right.
but you're a public citizen. Our board liaison is Tom. So you're a public citizen, you should, they have to leave.
Who comes up with these rules?
I don't know.
He's the town supervisor.
We didn't make them leave.
He's
We
not a
left it up
member
to
of
them
the
as an
board,
option.
but you made a public citizen.
Well,
No, Kurt wanted him to leave because he was leaving. He was saying that he wanted him to leave.
Okay, so it's the same way with Sean then. Because Sean's not a member of this board in this capacity, he's a public citizen. Tom is our liaison to the town board.
Oh.
What does this have to do with?
Lance, is that a legal, I mean, does he have to leave?
They have, as town councilmen, they have the right to be here.
Okay,
It's crazy. It's just,
so,
Okay,
I
yes,
mean, let's get on with it.
I agree.
Come on.
Stand by it.
If you agreed, you wouldn't be posted.
So,
No, I mean, if Lance is saying that it's okay, and he's going on record saying it's okay for,
I'm going on record.
good, all right, then he's fine. I'll move on. I'm gonna run the meeting less, but I do have other things that I wanted to say.
okay.
So whenever you give me the floor.
Well, I want to start with what the purpose is why we're here tonight. We're here to discuss the changes that were made to the town law.
Proposed changes.
The proposed changes that are to the town law for the wind energy, okay? On the back side of the last 2 pages were highlights, this is of the seeker that we received from the town. There's, the last 2 pages highlight the changes that were made.
Do we have that?
We'll be back on the back page.
I have all the changes here.
No, I don't.
What do you want those yours, please?
Oh, you betcha.
So with 4 of us here to read these and to vote, and we form a quorum between the 4 of us, I would like to read down through these changes, look at each one through the in the local law, have a little discussion on them, okay, and then move on to the next one. Do you want to?
Yep, I think I'd like to try to save us all some time.
Okay.
The proposal to change the wind ordinance was brought up 2 years ago. And at that time, less than 2 years ago, was that we decided to make no changes. Okay?
Yeah.
Here you go.
I need to.
So it was decided to make no changes. You guys can't be here if it's closed
Okay,
meeting.
okay.
Your phone's out there, right?
There's just a misunderstanding, so we
Yeah.
thought we'd just come in and check.
Okay, your phone's out there.
Yes.
Lance said the council people can be here, so
I'm
if
gonna,
you want to talk, carry on.
all right, very good. Go ahead.
So it was voted at that time, 2 years ago, less than 2 years ago, we weren't gonna make any changes. I went through the history, I'll do it for Eric real quick, because he wasn't here last time, so bear with me, you guys. The, right after that, decision was made by the town board, within a couple of months, 2-3 months. Heritage Wind proposed $50,000 to look into our wind ordinance. It was discussed, never voted on. The consensus at that time was not to take the money. It came up again the next month, was brought up again. The consensus was not to take the money, but there was never a vote on it. Rich Bennett couldn't make the next meeting, and they brought it up again. This time they voted on it and took the money. At that point, the way they got the vote passed was a person that should have recused themselves voted and shouldn't have. Yeah, it wasn't right. I kind of lost it. And the next meeting came up and it was like, you know what, that was an illegal vote. We got to do it again. Rich Bennett wasn't there also again, and this time it went through pretty much because it was like, let's move on. This is far enough. Let's just go ahead and take the money and go, which I didn't agree with. So that's the reason that this has gotten put down the road and came up. At that point, there was a lawyer, there was a engineer from UB that was hired to look at the wind ordinance. For $50,000, the report that he gave us, this isn't it, is it? This isn't it. So I don't know where that is. We should have that to look at because there wasn't much guidance in that. From that, the town board took it upon themselves to work to make these wind changes or to look at it and make the wind changes. I don't know if they'll admit it or not, but it was heavily guided by Apex of what they needed in Heritage Wind.
How's this,
To the point relevant, because I will.
please get to the point, because we're time limited.
I'm trying, I'm also talking to the public, because that's one of the things, the public has no idea what's going on.
You don't.
So, no, and if you read them, let me get to the point. So, they went through, worked it out, came back to the town, and at a town board meeting, ready to discuss it, it was presented that the engineers from Heritage, or the lawyers that were representing the engineers, said that it wasn't, they had to change it even more. That's the wind ordinance that they want us to look at. What I'm proposing is that our town is based on the comprehensive plan. Our comprehensive plan is 2008. We should have had that done sooner. Up to this point, the public has no real say in this matter at all. When it was first presented, it was coming down from the state. It was a done deal. There wasn't anything we could do about it. That was the general information that was given. I think before we change these laws that can change the total character of this town for the next 20 to 30 years, we should allow the public to have some input. And I feel that we should make the opinion to take back to the town board that no changes to our wind ordinance until we change relook at our comprehensive plan and get public input. That's my point. And I think we could.
Are you making that a motion?
No, I think we should discuss it more because I have a lot more things that I can back it up with if you're willing to back me up with it, yeah, I will make a motion.
No, I think Wes runs the meeting, not you.
You're just asking if you want me to make a motion.
Well, you're asking me what I think.
Are you making that a motion?
Not at this point.
Okay.
I have other things that I can discuss with you. The survey that I did, I know it's been said that it was biased. It was, when I looked at it and I said, how can it be biased? The things in there, I didn't bring a copy, I'm sorry, but the things that I wrote are exactly the things that are in our wind ordinance as problems. Point out. I pointed out the taxes, the tax benefits, which we don't know what it is yet, which I think we should know that before we change any of our wind ordinance. And I think that the public, with the survey that I got back of 35%, do you guys know the numbers that I got? Have you guys read the hub and know what the percentages are of the people?
Many of these are things that should be addressed with the town board right now. The reason this is back to us right now is for us to review the changes that are proposed changes that the town board has made to this law, and we're to look at these individually, and everything else should be going to the town board for their review and approval, and not, I mean, you're hashing out old business that needs to be taken up with the town board and not with the planning board.
Can I address the board?
Yes, please.
All right, a couple of things. First of all, we did hire somebody from UB. There was a fee reimbursement agreement that was made with Heritage, and the reimbursement agreement said that regardless of whether the town made any changes to the law or not, they were going to pay that. And the reason for that is because the town itself doesn't have the resources to pay those kinds of fees. Secondly, the survey that Mr. McKenna prepared was not something that was done at the behest of the planning board. It was he did it as a private citizen. So I think it's objectionable for him to come to the meeting and say that in some representative capacity of the town, he did the survey, which in other respects, in my personal opinion, was flawed. They extrapolated information. It wasn't, they had a certain response, and they extrapolated a percentage based on the response rather than the actual, just limiting it to the actual responses they received. The town board did not make these changes lightly, and they didn't do it at the behest of Heritage. In addition to input from Heritage, which is normal, we also had input from Labella Associates, which is the town's environmental and architectural firm, and they deal with these all the time. They have a lot of background experience in these laws. I did a comparison between what was proposed by Labella and what was proposed by Heritage, and they were almost exactly the same. And the reason for that is because these criteria, these standards that are proposed are basically the standards that the siting board, the state has adopted in the last half a dozen projects that they've approved. So it's not a question of, kowtowing to Heritage by any stretch of the imagination. It's a question of what we believe was reasonable. I will say that there were many, many, many hours spent in debate at the town board level with regard to these proposed changes. And that's how it comes to you now.
Okay, so as far as the siting board and that, siting board is presented by Governor Cuomo. Governor Cuomo has his that he wants to address this in the year 2050. And it's totally skewed towards doing that. There's not much representation from the town, so you lose that. At the same time, they're gonna do the minimum. And I think we saw that on our battery storage once from, so I wouldn't take anything from NYSERDA as that's gospel. That's minimum, just to get by. I have done many, many, many hours of research on this, and I wish that other people would also. Told everybody to bring their computers, because we could get online and start right now researching this and going through it. But you know what? I think we need to speak for the town. I think we need a comprehensive plan brought up to date so that the town has some input on this. And so I will make a motion that we put back to the town for the recommendation that we update our comprehensive plan before making any decisions on changing our wind ordinance. They knew what it was coming in, and so, but
Okay.
that's my recommendation, that's my motion.
So we have a motion, we have discussion. Can we look outside of the three of us for discussion?
Well, I don't think that's,
No, but you gotta have a second.
No, I'm just open to this discussion and see if there's any discussion, and we'll ask for a second.
I mean, I'll address the board if the board wants me to address the board. I don't want to just
Okay.
hop in.
It's our job to do as a planning board to make sure the comprehensive plan is up to date. That was one of the things that I talked with them in New York when I called about this. They said you need to do your comprehensive plan. So I'm not just saying this because I want to throw the weight around. No, this is our duty for the public as a public service.
And our comprehensive plan information would come from,
Comprehensive plan information would be a survey of the public and to see what they want.
it also comes from experts like Labella and that also. That information is involved. Can I have a second? I can have a second.
So just so that you know, I am informed that a new comprehensive plan was adopted by the town in 2018. So
Correct.
2018.
I know you were way off, I didn't bother.
Really? Okay, I did not know that, I did not realize
And
that.
I just want to point out, we're getting into this thing about, people were advocating that we should have a referendum on this, and we've had surveys. And I'm not saying it's right or wrong, but the way the system is set up, the ultimate decisions will be made by the siting board as to whether they approve the project or not. And there is also now a new process, this is called Article 10 of the Public Service Commission. There's a new set of laws and regulations that have come out, which is Article 94C, I believe, and I can't remember if it's executive law, but I believe that's where it is, which actually removes further authority from the townships and municipalities and places it with the state. I'm not saying that this is inevitable, but there is a process that we go through. First, we have what I would call the presentation of this law, the consideration by the town planning board. There's going to be a public hearing at the town board level regarding this. Then it has to go to the county planning board for review, and then it goes to a vote. So it's not something that is just being done, in my opinion, because I spent a lot of time on this, it's not something that's being done willy-nilly, and there's an awful lot of opportunity for opponents of the wind law to voice their opinion and to go on record, including at the state siting board, which basically is almost like they hear objections from different parties. And God knows everybody who's opposed to it is a party to this proceeding. So they have the right to put in whatever arguments, whatever data, whatever scientific information they have, ultimately for the siting board to decide yea or nay.
Thank you.
So, people don't get a chance to voice their opinions at these because they can, but they're not listened to. It's the same thing that's been happening for the last 4 years. People are not being listened to, or they don't even know what's going on.
That's incorrect. And
No,
you know
it's not.
incorrect.
There's
Board
opinions.
meeting after board meeting after board meeting, people have gotten up, pro and con, some people ranting and raving, some people standing on tables with banners. You know what
And
I'm talking about. So
And, right, but the general public,
don't distort the
the
truth.
public doesn't know.
Don't distort the truth.
The public does not know what is going on.
Does know, it's been
Does
going
not
on
know.
for years.
And you can look through the opinions of what they said in the comments, of my survey done by a private citizen. So, I am speaking up for the public of Barre.
No, you're speaking out for the opponents of the project of the town of Barre.
No, I am speaking up for the public Barre. I am speaking up for everybody. There's other people in this survey that had mixed opinions on where to go. I will speak up for them too. They thank me.
All of us here are representing Barre.
Thank you.
You are dominating all of us, when you shouldn't be. You are one of us, not all of us. Let's talk in
Let's
that
talk.
context, okay?
Okay.
We're trying to run a meeting. We haven't been able to get past the agenda, the very first item of the agenda.
So,
And I would say it's all because of you. How do you dominate a meeting like that?
because I've done the research and looked at the facts and talked to the public.
What does that have to do with our agenda and trying to accomplish what we're doing?
I would like to work down, start on the section 1, work through each, or just talk about each one of these. And then make a proposal at the end. Okay?
Is it true that Heritage Wind knew what our wind laws were when they came in? Why are we changing our wind laws for them now? When Vance said, New York State is gonna make the decision. We don't have to. Why are we changing our wind laws?
Did you read down through these changes here?
I've read through the, yes, I've read.
Okay. Most of these that I have read were changes that were in line with other communities.
700 feet is taller than any wind turbine in the country.
I got that. You're talking about one instance.
Change from our property lines limits our public's right of how their property is gonna be handled.
Okay.
The noise is not qualified to the World Health Organization.
Shouldn't we cover that as we're going through these? How about some semblance of order here in doing
That's
this?
why I asked if I could speak. Wes, you
Okay.
had a question, if you want to take it.
Sorry, I'm just got here and I just have a quick question because, is this open to the public?
iPhone,
By phone?
iPhone,
So,
and video.
and video, okay. So Lance, then the question is that, you had stated that Sean was allowed to be here as supervisor, Tom is the liaison, me as a town council person. Does that put us at quorum?
What? No, you're not part of the board, you're here as an elected official, you're not a member of the planning board.
Okay, so I just wanted to make sure that we're okay, open meeting laws wise.
You know that.
That was my only comment.
You have 4 members here at the planning board. Okay.
Thank you.
So, let's start with the first one. The letter at the end of the seeker, the first one says, section 350, 103, 1, A and B, requires applicants to correct interference with existing communication links, telephone transmission lines, and fixed broadcast or reception antenna for radio, television, wireless phone, or other personal communication systems. The way I see it, that was added to the,
That's something additional that wasn't in the original law?
Just to, something else, just to bring your attention, I don't want to dominate the meeting, but we were handed this, that these are all the corrections that were being made to the wind limit.
they were notes
If
of
you-
the changes.
If you want to come around, and yes, it's just little bits and nothing, and I don't know, I haven't, but if you want to come and see, I have the wind ordinance changes highlighted in red, 60 pages, and I think it's going to be a little bit more than this, just so you're aware of it.
What were the changes?
If you
Most
wanna
of them
come-
most of them that I found were typographical.
Right, if you want to come and see it.
Well,
Am I-
we're
am I wrong?
looking at section 350.
Did you have a red highlight?
I did it at work, and I compared the 2 documents
So
at work,
you did it longhand?
and yes,
Okay, just come take a look, it's pretty cool.
many of them, I let Word sort it out for me,
Okay, all right.
and so that I
Many
could
of
see
them were,
what,
exactly, but I just wanted the public to be aware that we are not looking at all the changes, although there are.
many of them were grammatical changes.
Okay.
The ones that were not are highlighted here. So, 1A and B, and that, so the changes, do you have both of them in front of you right now?
I have it read, yeah,
And the changes are
yeah.
specifically
For which one, this one?
A, 150,
350,
103, 1A. Change from what to what?
Let me get to it, I just was going through the other changes. I mean, because there's a lot, I mean, that's what I was trying to show you guys, but you don't want to look, that's fine.
We want to look at one at a time. Shouldn't be too hard to understand.
Okay. Each page had a change and changes. I'm getting up to page 19, and just so you know, we're not going through them one by one. Because
Just to help you, it's on page 13.
Would you?
This one is on page
350-103A.
22. That's how many changes were made that are changed in the book. That's okay.
The change in A was the applicant shall correct or document significant progress toward corrective action on any unforeseen interference to the satisfaction of the code enforcement officer within 30 days of any complaint being given to the applicant by the code enforcement officer or affected person to correct such problem. That's the change, addition in B. It's the last sentence where it says the applicant shall correct or document significant progress toward corrective action on any unforeseen interference to the satisfaction of the code enforcement officer within 30 days of any complaint being given to the applicant by the code enforcement officer or affected person to correct such problem.
Okay.
So how's it different from what it was?
It just expanded the language in terms of enforcement.
It expanded the language to what, I'm sorry?
For enforcement. Enforcement.
For enforcement.
So it's actually a tighter,
Yes.
more explicit.
Yes. More restricted, correct.
Okay. And did you cover B as well?
Yes,
Yes.
That
same
was
thing.
B, that's what I thought, okay.
So both of these additions would be to the public's benefit?
Correct.
That sounds reasonable.
Okay. 1F.
Same thing, 350,
And that one-
103.
And it prohibits the use of guy wires for turbines, meteorological towers, or transmission infrastructure, primarily due to the unsightly appearance and potential safety concerns with guy wires.
Correct.
I get that whole
So
thing.
So that went into more of what you,
That was added.
That's an addition.
okay, I didn't have that addition.
And I don't see it, I mean, makes sense to me.
So it reads, it just basically reads that particular subsection. The use of guy wires is prohibited, except if otherwise unfeasible in the case of a wind energy conversion unit / wind turbine, small project, meteorological towers, or transmission infrastructure. So, so it's no guy wires. So basically, for the wind turbines themselves, there's no allowance for guy wires.
If I see that correct, is that is an additional restriction that wasn't there before?
Yeah, it was clarified. Yes, it was added.
And this seems to be more restrictive than what you read
And what was
just
previously,
now.
right.
Yeah. Okay. 350, 103, 1H. Establishes a setback distance of 2 times the tip height for existing residential or commercial structures. This represents a change from the former setback of not less than 1,000 feet from an existing residential or commercial building. In the majority of cases, the change in the tip height standards will result in an increased setback distance for utility scale projects. The setback distance is 1.5 times the tip height established for property lines, public roadways, and power lines remains unchanged.
So actually, the previous, again, the setback was expanded for further protection for residents that have either residential or commercial properties.
So those setbacks should be from the property lines.
They are setbacks, the 2 times the tip height is from non-participating property lines. So anyone who is not a participant in the program, doesn't have a lease, doesn't have a turbine, the turbine has to be located at least 2 times the tip height. And if you're talking about, I think their towers are talking about 680 feet, so 1,260, is that right?
I think we should be.
1,360, excuse me. That's why I'm a lawyer, I'm not good
I
at
feel we should be protecting all of our citizens, and shouldn't be, making changes, because if those people sell their homes, the new people, the new residents are gonna be saddled with those same problems. And so I don't think that should be done. The other thing is, We got this information. Did anybody else do any information on their own and checking the experts? Okay, this is where I told people to bring their, because there are many universities out there that are WIN university experts. And if we get on there and we talk to people, and we talk to the professors, or we talk to the lawyers that they have on staff, they will take and give us recommendations that they go by for safety without costing us money, $50,000. Here's one that I did. I talked to Texas Tech Institute. It's the WIN Institute at Texas Tech University. And talked to a professor there who's a lawyer. And where's her comment? Setbacks. Suggested setbacks of 3 times the turbine height from blade to tip from a property line and a half a mile from a residence. Many ordinances are only 1 turbine height from the property line, so don't expect.
So the existing law says 1.5 times. We're expanding it to 2 times. You're suggesting we
3
should have.
times, 3 times, and
Where does it end though?
half a mile from residence. It ends when we feel that we're protecting the citizens of our town.
It ends when the people who are opposed to the project have prevailed. That's basically what has happened here.
Or we could let New York State make the rules and go back to what we were told at the beginning, we don't have any say in this matter. But yet here we are trying to have say in the matter.
Yes, we are. You don't think we are?
No, I think we're going right into Heritage with what they want. We're following their recommendations.
No, they're not just their recommendations.
Their recommendations to make it,
Professional recommendations.
you're telling me that their recommendation is to make it more restrictive than what's already in the wind laws? We're going to twice as opposed to 1.5.
And I just read 3
You're telling
times.
me the Heritage wind, why would they want to make it further? Why would they leave it at 1.5?
I'm saying
The
that
town is expanding, we're trying to accommodate.
The other thing that we can go on for throw is setbacks for safety for blade throw, for snow throw from the blades.
I don't know if that's another one.
It isn't. I have been working on that. That goes to setback. I have been working on that and haven't been able to really, up until a month ago, come up with a scientific thing for that. I got a lot of professors that said, well, I'll just work it out real quick, and here it is, you're looking at about 1,500 feet. I came across a formula that I worked out for blade throw. That one came out to 1,800 feet. It should be a setback of 1,800 feet. What I'm trying to find now is if that formula, if they'll go by it. I tried to contact the engineer that we hired, and I called him 3 times, and he's never returned my call.
Right.
I probably, the next step is I'm gonna ask the Texas Tech lady and see what she says about it. But I think that would be
My
scientific.
point, listening to the way this conversation is going, you had 2 or 3 other engineers tell you one thing, and you were looking for the absolute worst condition.
No, 1,800,
That's
the
what it
worst one is 3, the worst one says 3 times.
Okay,
So that'd be 2,100. This is saying safety-wise, it worked out to be about 1,800.
okay.
That would be, I'm looking for safety. I'm not looking to kill the project, I'm looking for safety for our public. I'm also been looking for the pros to this, but nobody's told me that either.
So, it looks to me, the town board is recommending that we go beyond what the original law is. I don't see that as being something that Heritage Wind would be in favor of so
Okay,
far.
but
And you're saying that
I'm
2 is
saying-
not far enough.
2 is not far enough.
Do we put that down as a note, a recommendation, that George says 2 is not far enough?
I would
How do you want your?
I would like to look at this formula, and if that formula says, it's right for how far the snow and the ice is gonna be thrown.
How do you want your opinion recorded or brought to the town board? Is it like, would you voice
On this
it?
particular matter, how would you like that put into the minutes?
I would like this formula to be looked at. I also found a thing that said scientific studies for setbacks, but it's only can be opened by a academic professor. I can't open it.
Okay.
I'd like that looked into. if we can get somebody to do it.
And that's, yep. So in the minutes, that'll be something that the town board can look at through our minutes as well. The next one, 103, or excuse me, section 350, 103.2, updates the town's noise standard to align them with acceptable standards currently being used statewide in other utility scale projects, and to make the noise standards easier to monitor and enforce. The new noise standards are defined more specifically for daytime and nighttime hours and for the participating and non-participating landowners in order to provide more appropriate levels of protection. Likewise, new standards are also introduced for the lower frequency infrasound bands, audible, prominent tones, and vibrations.
So again, if I may comment, these were the recommendations from Labella. And I said I did a comparison of what Labella has provided and what Heritage provided. They are pretty much on the same page. We have actually tried to enforce some better standards. For example, in our old law, I think it said the noise limit was 45 dBA, and it didn't vary whether it was daytime or nighttime, and it didn't vary whether it was a participating property or a non-participating property. So those were changed basically again because of what the state has found to be acceptable levels of noise. We did reduce the 45 dBA to 40 dBA for nighttime at non-participating structures, and so we just, basically, it's consistent with what the siting boards have agreed to. You know, I don't think anybody is going to legislate a perfect law with regard to any of these matters. I don't think there is such a thing as a perfect law. I think that it's a matter of what is reasonable, not what some faction wants as the absolute best or the absolute worst. So, you know, we're taking recommendations from people who are essentially working in the town's interest, that being LaBelle Associates, not Heritage.
But am I correct to say that the proposed changes to the noise is actually more restrictive?
Some yes, some no. More restrictive in terms of non-participating structures, less so with respect to participating structures. The idea is, look, if you have a lease with the turbine company and you're getting money for it, then theoretically you're going to put up with a little bit more noise than somebody who's not receiving money from it. So that's why the differentiation between participating and non-participating.
So if they sell their home down the road, people that buy that home have no say, they have to put up with that.
They do have a say with
Somebody who buys their home
They don't buy the house.
will be on notice
That's their
through various means, including recorded documents, that there's a lease with Heritage.
Not only,
So
not only are they benefiting from the fact that they're there, they'll be getting the lease money.
if that's what they want. If they don't want to buy the property, they don't have to buy the property. It's really very simple. It's not a matter of they're going to go into this unaware of what's there. I mean, one, it's visible. Number two, these are documents that are recorded in the county clerk's office. They're public documents. The realtor should be aware of them. The property owner should be aware of them. The lawyers handling the transaction should be aware of them. That's it.
And they're getting monetary benefit from
And they're
it.
getting monetary benefit. And that argument is the same whether it's a wind turbine or a cell tower or any other structure that's not, you know, not a tree or a bush.
Okay. Discussion. Moving on to the next one. Section 350, 103, 4. updates the lighting standard for WEX to require the incorporation of aircraft detection lighting systems, that's abbreviated ADLS, or other similar lighting minimization technology or technologies at the WEX that avoids visual lighting impacts at night. The use of ADLS is a recently utilized and approved technology in New York for minimizing the local lighting impacts from WEX while complying with the aircraft safety requirements of the FAA.
That is a new provision.
Hey Wes,
Yes,
can we go back to the 350-103-2, as far as the noise goes? I'm not a noise expert, I don't think anybody here is a noise expert. I would like to, as far as comments to the town board, look into that and get an outside source to see if our public is protected.
Okay.
And if there could be a problem.
The
Any,
lighting does impose an additional requirement on the developer as far as lighting standards to avoid visual lighting impacts at night.
So the way I understand this then is, they will be dark until an aircraft comes, and then they'll all come on. So if there's no aircraft at night, they'll be off, no lights.
I can't answer. I can't answer.
That was my understanding at one time.
Sean?
This is one, I remember way back, George, where you were complaining about when you look south towards Batavia, all you're gonna see is a whole series of red lights.
You
And,
see it now from the top of the hill. You see Attica, all lit up down there.
yeah. I was on a panel about green energy down at Cornell University. Well, not at the university, but in Cornell, Ithaca. And after we had our session, one of the gentlemen in the group, who was a lawyer, came up and he told me about these aircraft detected lights. And he said, yes, they are off at night until an aircraft comes within a certain distance, I don't know what the distance is, then they turn on automatically. And they stay on for a period of time, which the aircraft should be well gone by then, and then they go dormant again. So that was one of the things that I brought back to the group, and one of the things that I insisted to Apex, that here's something, it's fairly new, but that would be something that we would benefit most from. And once again, it was because of what you had said before.
John, do you know if small private planes would have that?
Well, not small planes or ultralights or anything like that.
No, but they would fly at night.
ADLS is a relatively new system. It's not just for lighting, it's for collision avoidance with other aircraft, because if you're ADLS equipped, airplanes will detect each other and notify each other that you're, give a warning. Same thing with towers around. I don't know the full extent what ADLS is, but it's a relatively new thing in the last 10 years. And we're trying to get, the FAA is trying to get everyone on board, but we got a lot of people with old airplanes that don't have electrical systems and stuff like that, so.
Does that mean the whole tower goes black if there's?
I don't know if it's, I'm more familiar with it in terms of
Yeah.
aircraft detection,
Yeah.
collision avoidance.
Right. Yeah.
Not with towers and
Yeah.
windmills or anything like that. But I don't see any reason why it wouldn't be expanded to include that. It's just another obstacle. You have to put something on the tower that looks like another airplane, and when you come near it, it'll tell you you're there, and it's all fluid. So,
Because most of them I've seen only have the red light on top.
mhm.
They don't indicate how where the blade is.
Yeah, that's true. But this ADLS is a plain transmission.
Right. So I don't know if we can answer the question that there would be a blackout if it was there, to answer you, George.
I think it's all about how they set it up.
Yeah.
They could set it up so that it's just, only the aircraft sees
Yeah.
there's an obstacle there. And And if the tower sees us as an obstacle coming, it would set it up so it turns on the light.
It's,
It's all a matter of how you set it up.
Right.
I don't,
but the amount of lighting that's gotta be on it is probably reduced because of this. Should be.
you wouldn't even need any lights, as long as you know it's there.
Okay. 350-103-6 updates the maximum tip height for WEX to 700 feet as measured from the base of the unit.
Just in conclusion.
Oh,
So
sorry.
this is just, is an additional requirement that wasn't in the original law.
Yes.
So again, we're expanding more provisions, more protection for the public, more protection for anyone involved. Sorry.
That's okay, thank you, John. The next one is, as I said, 350-103-6 updates the maximum tip height for WEX to 700 feet as measured from the base of the unit to the tip of the unit's longest blade. The proposed revision represents an increase in maximum tip height from the current height of 500 feet.
So if I could speak on that, that's one of the things that, they are raising this because, I believe that they're raising this because there's not enough of a wind source in this area. When they first came here and they put the Met towers in, I was told, don't get all upset, we don't even know if there's enough wind source in the area. I believe at this point we know there's not enough wind source in the area, even though they were just giving us the lowest heights. The unit that they want to use, the Vesta, whatever, if you look that up, their whole purpose, their whole main advertising thing on this Vesta unit is this is what you use in a low wind area. So pretty much we know where we're at.
Well, there's the added possibility, we were just conjecturing here, or theorizing, is that by going to higher heights, they don't need to put as many in.
Right.
Which gives them an economic advantage.
Plus less environmental impact.
And less,
If-
positive side.
If
But,
they don't have to put as many in.
but this issue is to me is a big one. Because this is not, it's not like they're lowering it from 500 down to 400. We got smaller towers now, we got taller towers, which are gonna have adverse effect to everyone in town. And it's always been my contention when it came to this one here, this particular one, is what are we getting for it? If we concede or if we expand to allow higher, what is the town gaining from this? Are they walking away because they went from 500 to 700 feet? Are we getting an economic benefit from doing this? Meaning, they don't walk away, they come in, that's an economic benefit if they don't walk away. But are they gonna walk away if we leave it at 500 feet? If they don't, then why are we moving it from 500 to 700?
Can I speak to that?
Yes.
Because I've had several conversations with the attorney for Heritage, as well as representatives from Heritage. What I've been told, first of all, is you're correct, that the higher the turbine, the better the wind, and so they don't have to put as many turbines up as before. Secondly, they have told me that leaving it at 500 feet will kill the project. Whether you believe that or not, I don't know whether to believe it or not, that's what I've been told. Does the town benefit? We have a community host agreement that we've been negotiating for quite some time, which would pay, they would pay $9,000 per megawatt of power, and that would be split up 75% to the town, 25% to the county, and to the participating school districts, which are Albion and Alabama. Oakfield, excuse me. That's all I can tell you. The agreement hasn't been signed yet. It has been negotiated, and so we're trying to get that formalized as well.
So that negotiation, we never really had a proposal. When they came in here knowing that we were gonna do 500 feet, that they had 500 feet to work.
Correct.
And they were in favor of doing this. They had a plan with turbines that were less than 500, 450 or 80 feet, and they were all, in the process of doing all this. We never really knew what kind of compensation we would get from that. So we can't really do a comparison and say, hey, we got a net benefit. I mean, is it more megawatts now that they have less
I believe it is. I
less
think-
turbines, it's still a greater number of
Yeah,
megawatts?
because the turbines themselves have a greater capacity, so I think the old turbines were, and don't quote me on this, but somewhere like in the 2 point something range, and these are like 4.1, 4.3. So they do generate more power.
So even if the numbers are the same per megawatt, you think, well, probably should get that clarified. Because I think people will want to know, what are we getting for going taller? And is it gonna be, I mean, if it's a no, if the project is dead because of it, then we know that we get zero, we get this if we go for it. I mean,
Well, that's what, again, like I said, whether they're being totally honest, I can't say. I can only say that I've been told, they designed this project apparently with the idea that, I think these turbines are gonna be 680 feet, not quite 700 feet, but that's how the project was designed. And they said that they cannot do an effective design at 500 feet. So they told us that the project is dead if that's the case.
I think we ought to realize too, that they came in with the proposal of having 48 turbines in this area. And because of the lack of people signing up and not wanting turbines in the area, they were down to 33. And of those 33, 30% are from people that don't even live in our town. So I think we should take that into consideration.
Yeah, I was just gonna say that, a couple of things. One is that the Lighthouse project, which is the same developer, they went through and they redid their wind ordinance to be stronger, and the project is still on file. Apex is still not actually withdrawn that project, and is still holding on to that project to move forward, whether or not this has happened. Second, the application.
Strongly mean more restrictive.
More restrictive to the developer. Second is that the application has already been submitted for this project. Unless they're planning on withdrawing the application, it has not been deemed compliant, but it has been submitted. And the third is that this change though is not for just this project. We make this change, and whether or not this project goes through, another company comes in and they're looking at 700 feet thinking, oh, this is a pretty great place to come into. So it's not, we're really, the focus should be on the wind ordinance and down the road, whether or not about the specifics of this project, but whether or not this is right for our community.
long-term wise.
Right.
And I know you don't want to go, the survey is biased, I don't believe it is. 83% of our population said if we change our wind ordinance, one of them being height, they're opposed to it. 83%.
I have just a goofy question. 500 or 700 feet, these things are extremely tall. Are you not gonna see a 500-foot tower compared to a 700-foot? Or are you gonna see them no matter what? And at that point, what's the right question to be asking?
The scary fact is that there's none in all of country, except down in Texas where I was, working with. That's a little scary. Why be the guinea pigs?
The other thing is, do they say it's density? I mean, we've heard.
The viewer decided to oppose the project. Under these circumstances, appearance would prevail that the proceedings goes on, but that's something for the board, you to determine, but
So,
I'm just putting out the information.
right, and with what Dean said, I will address that. I was on the Planning Board, New York State Planning Board training session today, and one of the questions in there going through was, if you have an opposition, can you be removed from the board? And it was said no.
That's
Okay,
different. Removal is not the
So-
same thing.
The other thing is though, I have been stating right along, I am not in opposition to this. I've been looking for the facts, I've done the research, and I'm just giving the facts.
You can try to convince yourself that, and you can keep doing that, but you're not convincing any one of us.
So that's what I'm looking for, is someone to convince me of the merits. Of
You
this
keep
project.
on this plan?
No, the merits of this project, but I don't need to get into this, but this is what I've been asking Heritage, and what I was told was I asked too many questions. Heritage told me that you're right. Well, you're not a normal, you ask way too many questions.
Questions is not the issue here. It's your ability to be impartial and to be objective. It's clearly not.
I am trying to give facts, I'm looking at things, I am not making things up. You can check all of my
I'm not blaming your.
I did a survey so that I didn't know how it was gonna go. I was looking to see what the town, how they felt. I was not trying to be an unbiased, I was not trying to, I was actually trying to see how this town felt. And I was surprised at the results, very surprised.
This is off subject,
Yes, it is. Agreed.
okay? And we can take this up at another time, but,
If we made a motion that he should be disqualified as far as being partaking in this, we will not have a quorum.
we won't have a quorum.
And where would we go from here?
Right.
That's a question. Where would we go? We'd be it?
We couldn't take an action. We would
If-
determine this to be no action taken by the planning board, and we'd have to go back to the.
Because we don't have,
Right, and if we have no action within 45 days, they can do whatever they want to. So I want to stick this out and represent the public.
I'm looking for some clear, impartial, objective outlook on this.
Anytime that I say anything that seems to be non-factual or impartial, let me know. Anytime.
We're talking about history, not what, from this point on.
Yeah.
But this point on would be good. We'll take that.
Okay. Very good. Moving on. We need to discuss that one. That one brought up a lot of,
The height,
yes.
I agree.
350-103-10 requires the WECs are designed to preclude the number of hours of shadow flicker falling on an area of roadway or residential structure from exceeding a maximum of 30 hours per year, while no formal regulatory standard regarding annual hours of shadow flicker have been established in New York State or the USA or other countries worldwide which rely on wind power. The maximum of 30 hours annually has become universally accepted as an informal standard.
And then we got, I'm sorry, I don't mean to, I think this is a little bit, the way it was drafted, but actually, the original law was 25 hours of shadow flicker.
Right.
At one point, we decided to increase it to 30 hours, and then based on workshops involving the town board decided to go back to 25 hours, so that's what it is right now. The only other change is that the previous law said that the shadow flicker couldn't be on any portion of a roadway, and so, based on input from Lavella, it says, look, you're in a car, you're moving, you're not stationary, it's not a situation where you're gonna be exposed to shadow flicker for any prolonged periods of time, maybe for a second or two. So that, we didn't feel that that was reasonable under the circumstances, so we took that portion out that said that shadow flicker had to be eliminated on any specific portion of a roadway, and then went back from 30 hours to 25 hours for shadow flicker for any I believe it's any structure, or occupied structure.
So a comment I'd like to make on that is I think we should contact the Department of Motor Vehicle to see if, or the state troopers, and see if they believe that, shadow flicker is an affected driver.
I make a comment. I'm affected by shadow flicker when I drive down the road and there's trees. And the sun is on the other side of them. Are we gonna, how far do I take that? Do I knock the tree, tell them I gotta take the trees down 300, 500 feet back so I can't see them?
So you're of the opinion it should be lower, or the setback should be from the road so that we don't have shadow flicker?
No, I'm of the opinion that shadow flicker on a roadway shouldn't matter, because it doesn't matter for other things.
It's just a reality of driving.
It's just a
down the road.
reality of driving down the road, you're gonna have shadow flicker from something.
And it is pretty temporary if you're moving.
Right,
Okay.
I get over it.
The trees pass.
The trees pass. I pass by the trees. It's gone.
Yeah, if the trees are passing you, we'd be
I'm
nervous.
in trouble. But
So,
we're gonna leave the 25 hours
That's what,
the way it was.
yeah, that was in the original, in our original
Okay.
law back in 2008.
Yes, it was. Yeah.
so the only thing with it, and again, I still think we should look into that, because you're seeing the trees, you're seeing the shadow in the trees, and you're knowing it. These shadows are gonna be from 1.5 miles away.
Okay.
You know, it's given, like, where did that come from? Just a thought.
Any other comment? Moving on?
Move on.
Okay. Section 350-103-12, construction hours, added new language to specify the acceptable construction hours in more detail in order to protect the residents from potential construction impacts of noise, dust, and truck traffic. How much of that changed?
I think we actually put in there that we restricted it to the hours between 6 AM and 8 PM Mondays through Saturday, without any construction hours on Sunday, except in cases of emergency.
So
I don't think that we had, as I recall, I don't believe we had a restriction on work hours or days of the week before, so this was, again, a tightening of the law.
I didn't see that in there before.
The timing is the same. The 6 AM to 8 PM didn't change.
Okay.
The Monday through Saturday did, excluding Sundays, and that it's a demand. I'm not going to read
What's
the-
the demand?
The new one says construction hours except for certain activities, cement pours, or component deliveries, or other conditions such as high wind speed during the day, demand from time to time require deviation from the hours set forth herein. No construction or reconstruction of any WECSs shall begin before 6 AM nor end after 8 PM Monday through Saturday. Such activities will be limited to turbine sites in the immediately surrounding area, except in cases of emergencies. All maintenance of WEC shall take place within those same time frames. And previously, it just said construction hours, no construction or reconstruction of any WECSs shall begin before 6 AM nor end after 8 PM, except in case of emergencies. All maintenance of WECSs shall take place within those same time frames.
Right.
So it seems to me they
Eliminate Sunday.
restricted it down to only Monday through Saturday,
Yeah.
no Sundays, where before they could do Sundays. So it's, again, more restrictive than the original law.
We'll go on to the next one. Section 350-105 introduces new details regarding decommissioning, including the required content of decommissioning plans, when decommissioning is required and how it is to be undertaken, and the required financial assurance to be supplied to protect the town against incurring the expenses associated with decommissioning. The revisions require that applicable permits are obtained and environmental review is completed prior to decommissioning.
Certain activity like cement pours, component deliveries, or other conditions. So that, when they're building and they're pouring cement, we don't have any say. They can be going 24 hours around the clock
Where does it say that? In the new law?
in the new law.
Says they can pour anytime they want?
Yep. Construction,
When you pour concrete, some construction, you can't stop pouring until it's done.
exactly.
You just can't stop.
And we're giving them, we could say they have to plan their time between 6 and 8, unless, in case, in case of emergency or something they have, but we're opening it up here to go 24 hours. So we can say.
Just pouring concrete, though, correct?
Example, cement pours or component deliveries also. So, I mean, the trucks would come in with gravel all night, and the delivery trucks would come in all night.
Okay. For that size project, I don't see that.
Well, like the silo for the ethanol plant, that's a slip form. That was a 52-hour pour. You can't stop, or you wouldn't have an ethanol plant in Medina, New York. So, I mean, you want to start.
Each one of these platforms, so we have to be realistic. I mean, what's going to happen? That was one of the complaints when I went down and talked to a resident in Sheldon, I think it was, and she said that once construction started for 6 months, she had trucks going up and down the road 24 hours a day. I mean, that's what we're opening it up to. I mean, we can say, oh, we're gonna,
How long do they say it's going to take to build one? What's the construction time?
I don't know.
year and a half, I don't know.
Tom,
I
you
don't
know
think
that
they'll
answer?
pour for a year and a half.
You know that answer? No?
I've heard him, Sean.
Yeah, we did discuss this at the board meeting and workshop meetings, and we did change the language, so that instead of saying that, which may, for example, certain activities, cement pours or component deliveries, which may from time to time require deviation, we changed that word to which may demand. So we try to make it a little bit more stringent on them, to use the word demand rather than simply giving them carte blanche or, or no standard to go by.
Okay.
We can't put anything in there as far as teeth that if they're outside of those hours, the town gets compensation.
You can make the recommendation to the town board.
Okay.
Yeah, we make that,
Sure.
put that in the minutes. Add that to our minutes for the town board to.
Compensation for outside of those times if they have to.
Yeah. Okay. Yep.
Justin?
Yep. Okay, before we move on, is that one?
I'm sorry, yes.
Nope, you're fine. Just make sure that was all done.
Decommissioning?
Decommissioning, we started on that one.
105.
105, yep, 350, 105.
Just so you know, there was a major revision additions to 350-105. Specifically, we added paragraphs 1, 2, 3, and 4. Again, trying to be more specific, more tighten things up, discussing what type of security the developer would have to provide for decommissioning, whether it be a bond, letter of credit, things like that. Putting in timeframes for the decommissioning. And I have to tell you that as far as Heritage was concerned, they weren't very happy with our time limits for what we put in here. They wanted it to start out at a year and then allow for another year, and so we held it down, I believe. I don't want to say the wrong thing here. It's 180 days with an allowance of an additional 180 days for good cause, so. it says is in paragraph 7, okay, that if a unit becomes inoperable, if they have 90 days from receipt of notification to make it operable for good cause, that period can be extended to a total of 180 days. And then they can apply, if they want to apply for up to an additional 180 days, but it's not automatic. It would be up to the town board whether to agree or not agree with that.
I presume that's from equipment failure that they can't get parts for
Correct,
or something
exactly.
like that.
Weather conditions, parts, things like that.
Okay.
Any understanding how we would know whether or not a turbine is non-functional, other than the fact it's not turning?
Well, they have an obligation to notify us too.
Is that special?
Yeah, there's an obligation.
And how do you, curiosity here, curiosity question. How is that enforced? How do we know?
There are penalties. Penalties of $200 per day from the time the applicant should have notified the town code enforcement officer and the date the wind energy conversion system or portion thereof is removed or made operational.
No, sorry.
Okay.
I misunderstood. How is that enforced that they are telling us that they're not working?
Well, I mean, I suppose if we can't come to an agreement, there would have to be some legal action taken. So,
Because I don't think it's not like a car breaks down the side of the road, it's broke down, everyone knows it's broke down, it's not moving. You know, gotta move the car, you know, something like that. This can sit there not moving and,
well, I assume that if it's not moving for more than a 24-hour period or a 48-hour period, somebody's gonna notice it, and somebody's gonna say something, and there's gonna be a complaint or some notice provided to the developer, and it goes from there.
most likely it'll be complaint driven.
I would
If
think
this
so,
thing's been
yeah.
sitting here for a month not moving, then they'll have to answer to someone, answer to the town.
From the planning board, we've had another another application where we've requested proof of generation. Is that something that is
Sure.
asked from these guys?
Yeah, absolutely.
Okay.
What I'm asking is maybe already in here. If it's not, then then I would like to propose it as a suggestion or that we find a way to make sure we know when they're working or not, and a verifiable way, you know,
Okay.
not just on their word. You know, I'm not sure how that would be done.
Well, I would imagine that would have to come through the grid. You know, if they're not putting that power into the grid,
Yeah,
that's gonna show up pretty easily.
yeah, we have visibility to power output, you know, that type of thing.
Yeah.
If we're given access, or at least the town board, you're given access to seeing what the status is of all the turbines, you would know whether or not one is active or not, and be able to, otherwise,
So it said in paragraph it says, non-function or lack of operation may be proven among other means by reports to the Public Service Commission, NYSERDA, or by lack of income generation. The applicant or its successor shall make available, if requested, to the town board all reports to and from the purchaser of energy from individual wind energy conversion systems if requested, necessary to prove the system is functioning, which reports may be redacted as necessary to protect proprietary information. So that is there.
so if they get a permit from us, they're under that obligation to be able to do that.
Yes, sir.
Understood.
Wes, we're gonna make suggestions to the board, and I'm gonna go back, I got a comment in here from the professor that I was working with at Texas Tech about decommissioning, and I'm gonna read that to the group, but another thing that I forgot to say, the ice, to answer a couple of your questions, the ice throw would depend on the type of turbine and many environmental issues. I would suggest getting a copy of the manufacturer's information on the specific turbine. This should contain the safe areas related to a specific turbine in terms of where protection equipment is required for workers. One can assume that if the manufacturer requires PPE, personal protective equipment, within 2,000 feet of a turbine, one should not want a resident or property line within that range either. So if we could, I have not been able to, no one's speaking to me, so perhaps Harry, if somebody from the town board could reach out and see what the PPE requirements are for this particular turbine.
Okay.
And then moving on to the decommissioning, one question, is there a decommissioning plan and bond in place for the project? This is a more fruitful argument to make than aesthetics or noise. The cost to decommission a modern wind turbine is 20 to 25 years, will be at least $1 million. The LLC that Apex has formed to build and own the project will dissolve when revenue ceases. This leaves an empty shell corporation with no assets, and your local landowners and community responsible for dismantling and disposing of the turbine. Wind turbine blades are not recyclable and will end up in a landfill. It is an ugly problem in our industry. This is a logical argument that hits the pocket. So we need to be more, aware of costs in the future, and take actions now.
One, can you tell me where that's stated from?
Yep, this is from Cassandra McQuillan. She's Texas Tech at the Wind Institute, Texas Tech University.
She's a professor.
She's a professor lawyer, adjunct lawyer for the National Wind Institute.
And in the decommissioning plan, that is something that is required to be reviewed on a regular basis to determine whether or not the security has to be increased because of any additional cost and removal of or decommissioning of the turbines. And that's what the security is for, that's what the bond or letter of credit is for, and that's irrevocable. So,
We just want to make sure it's high enough to cover.
Thank you. That was my next question. It was revocable. Okay, moving on. We have 350-106-5 requires compliance with New York State Department of Ag and Markets guidelines for agricultural mitigation for wind power projects. The town values its agricultural resources and wants to ensure compliance with accepted agricultural protection measures.
again, that's another tightening up of the wind model.
And to add a little bit more to that, the new one reads, compliance with New York State Department of Agriculture and Markets guidelines. The applicant shall plan, construct, and mitigate the facility consistent with New York State Department of Ag and Markets guidelines for agricultural mitigation for wind power projects to maximum extent practicable. This condition also requires the applicant to locate collection of wires and facilities, components underground in primary agricultural land, except where in consultation with the New York State Department of Ag and Markets. The parties agree that subsurface placement is impracticable. The applicant or environmental monitor will consult with New York State Department of Ag and Markets staff during construction when deviation from guidelines is necessary. Mitigation measures shall include full restoration of temporarily disturbed agricultural land.
So 5 and 6 are additions to the existing, they're not modifying existing paragraphs, you're adding these to 106. Because these things, environmental monitor, the last two, there's 6, 5, and 6.
Or in the,
Compliance with New York State Ag and Markets.
Right, that's the paragraph 5,
Yeah,
On page 20, I think it's page 21, right?
yeah, I'm looking at it.
Yeah,
But
that's
that's-
new.
but
What we
it's-
added.
But it's not, that's an expansion
From the original.
from the original, because you don't have anything in the original that pertains to ag markets.
Correct.
And same thing with 6, the environmental monitor, that's in addition.
Correct. Yeah, they are intended as additional safeguards.
All right, so these are additional restrictions or
Additional restrictions that New York State Department of Ag and Markets has to be consulted or be a consultant in the project.
And
in addition of environmental monitor, which is another oversight having to do with that's the last one, right, number 6.
Yes. Right.
He's adding in, oversee the compliance with agricultural requirements, restoration. So there are added requirements for decommissioning, right?
why is it that we took out the reforestation?
We took something out?
Where is that?
350, 106.
106 where you got
Restoration?
5 paragraphs in 106.
350, 106, on the first one. Landscape unless otherwise read in writing, cut or turn the close possible natural, including unlimited to restoring the subsoil and topsoil to pre-construction and condition and reforestation of at least 40%. We got that just crossed out.
That's a different change.
That's what I was saying when we started out, that not all things are out here.
Is it significant? It's different, but what's the difference?
They know 40%. I mean, it's like they don't have to reforestate it up.
Now we put it in here, mitigation measures shall include full restoration of temporarily disturbed agricultural land. That's in paragraph 5 of that same additional paragraph.
Paragraph 5.
So rather than limited to 40%, you said it should go back to full restoration.
Full restoration, okay. Perfect.
Excellent catch, George.
Full restoration of disturbed agricultural land, but that's not wood, that's not forestation. So, but, I mean, the farmer's probably gonna wanna have it as farmland rather than put it back in the trees.
Well, they may not want it. I mean, that's the other thing here. The property owner may say, we don't want it to be put back to its previous condition. We want to do something else, and that's up to the landowner.
Right, right. But if they did want it back into woods, this is agricultural land, can that be under a wood forest?
Right.
Good.
Okay. That is the end of the ones that I was made aware of. Are there others that we can look at right now?
That was time, George.
I guess my big four were height of the turbine, noise levels, the property, the setbacks, and the setbacks from property lines, because I don't think they should be from residents' homes. That has the application to whoever owns the land, and they could be limited, because, you know, you have to have a certain setback from there, and it's going from home, and if you want to do anything here, well, it's not going to be far enough away from the turbine. So you just lost your property rights to do anything. I could come up with an example if you wanted to, a specific one. So that's one. And the other one I had in there was, she was saying a half a mile from residence home setback. I think we should look into that more.
Okay.
Okay,
So are we gonna try to put together a list of comments, suggestions, reports, that we all agree on to go to the town board? What form does this take, other than minutes? Or is minutes enough?
I'm wondering if minutes is enough, if we can look at the minutes.
Town board will look at the minutes.
Right. We need to look at our minutes and approve them, make sure that they were concise, that they're accurate, and then give them to the town board and let the minutes be our direction that we discussed this evening
As our input.
as our input. And let the town board continue and make actions on it as they see fit. I guess, are we at the point, right this evening, or are we at the point, does anybody want to make a motion?
Well,
I think the other thing that I really think you guys should take some time and contact some of these people and talk to them one-on-one, so you can get the same, you probably get the same experience I get. The people that we talk to, you know, like I went with Penn State, Texas Tech, and there was another one. And these people that's their livelihood. They want to see these succeed. And I didn't go in blindly. I went in and said, I'm on the planning board, I'm looking for the safety of the public, you know, what's the recommendation? That's all I said. Where are we coming from? I didn't say I want to kill this project. I said, this is what I'm going to do. Can you help me? And they were very knowledgeable and very open. But I think what you're going to run into is, and it'll be interesting to hear what you say. One of the professors we talked to at Penn State was dealing with the wind and the amount of wind in this area and how to read it and that. And then we got on setbacks, and you get talking with them while they have a family and said, okay, where would you feel comfortable as a setback for your family if you were going to live near a turbine? And without hesitation, she goes, at least 1 mile away from my home. I go, can you go on record and say that? Nope. Nope. And it's those kind of things, it's like, you know?
those things would have been useful back when we were originally making the zoning laws for windmills 10 years ago.
Yeah, well, we just talked and we were informed that the comprehensive plan was made 2018. I don't remember any public input on that. And I was very much involved in it at this time.
It's the same thing when we passed the wind law. There was nobody, it was maybe
2018, the comprehensive plan took us 4 years.
Okay.
4 years, but how many people showed up for the public hearing?
And yes,
Oh, no, yeah, and we had public hearings to ask questions over it, it didn't,
in 2018,
yes.
see, I was not, and this was going on, that we should have been right there, because we've been coming to these meetings and the town board meetings right along. And I do not recall those at all.
It was long time.
I mean,
And as part of that comprehensive plan, 1 year during the election, we handed out surveys, people that were coming in, voting. I was surprised at how many we got. We got a pretty good sample, as opposed to originally we started with a website survey.
in 2018,
Yeah, like
This was prior to this whole, our last comprehensive plan took us approximately 40 years to develop.
so,
At
To read,
least.
yeah, so over that time, we asked for town input,
We actually had a survey.
and the survey was fantastic. We
And
had
the
a lot
survey
of,
was added to the comprehensive plan.
Yes, it's in the back of the comp plan.
yeah,
Yes, it
there's
is.
not, yeah, but there's not much in there, there's some comments, but there's not.
I remember there was something missing here. It was
Yeah.
supposed to be the result of the.
Yeah, it's just comments.
I remember.
Because I was looking at that, and I thought that was from 2008.
You're correct, I remember looking at it, and that data was missing. It should have been much more comprehensive than what was in there. And I do remember making a mention of that in one of our meetings, and it was already passed.
But that's something that,
But it does exist. Our survey data from that survey exists.
I can look it up,
okay.
get it up.
But I don't know, that's one of the comments that we were getting from, if you go through that, is people feel like they're not being heard. People are not being informed. I mean, and the comments, not everybody, we had 254 responses. There's 6 more that I haven't opened yet. But probably 25% you did make comments. And so it's interesting, and I have a hard time, because I want to listen to it. I don't want to ignore those people. Because that's 256 respondents, that's households. So a lot of those households have at least 2, 3, 4. So now you're looking at, 6,
they went
7
out to,
people.
but they went out to individuals in the household, did they not?
They went out to the household and they were returned as a household. So
Okay.
it was supposed to be, and that's one of the things that if I was to do it again, somehow I'd want, because it was one poor family that responded to 2 spots. Definitely didn't want it, definitely wanted it. So.
Okay.
I just wanted, there's one more change that I just think, if you could just look at. It was on, it's not included in the overview, but it's in regards to temporary net structures. Standard for wind measurement towers is section 350, 108, wind measurement towers, standard 3, section B. Special use permits for temporary wind measurement towers may be issued by the town board annually for a maximum period of 3 years. And then this is the addition with annual extensions up to an aggregate of 7 years, subject to annual extensions up to a maximum of 10 years. Special use permits shall be renewed annually if the facility is in compliance with the conditions of the special use permit.
What's your comment?
That's opening us up for temporary structures.
Significant, going from 3 years to 10 years on a temporary structure, 10 years. So, okay.
How many more of those changes like that are not listed in our, that we just went over?
I was hoping you could have an answer, because you had that all.
I know, I wanted to show you guys, I didn't, but that's one of the things, Carrie brought that up, I did notice that before when I was reading through everything. I took the easy route here and said, oh, it's gonna be all in here. It's not.
Wes has a condensed version, you have the complete version, you're on the board, if you have something you see that's significant, I would suggest you bring it up.
No,
I mean, there's one here, 11, that we talked about.
Here.
That's the old one.
351?
Yeah, so this is.
350.
Yeah.
So this is.
350, 105, 11.
if you're talking about wind measurement towers, what we did was we said that the town, wind measurement towers may be permits issued by the town board annually for a maximum period of 3 years with annual extensions up to an aggregate of 7 years. And then we deleted subject to an annual extension up to a maximum of
Looking
10
for
years.
the 10 years,
So it's an aggregate of 7 years, and that's after the initial 3 years. That's based on an application that's made to the board, which would have to agree or disagree. It's not an automatic.
So did the 10 years get taken out?
Yes. Anything that was italicized was deleted. Yeah. Anything that was added was highlighted, anything that was italicized was deleted.
Oh, see, this was italicized and highlighted. That's why I was confused.
Not mine.
Okay, so.
Okay.
I'm sure you looked there. But it's,
It's an annual extension,
It's an annual extension.
up to 7 years.
the taxes, I mean, if it's 6 months, it's normally very restricted.
And, well, and who approves that? I mean, does that structure have to be, does an engineer have to approve it, that it's structurally sound to be there?
Town board would have to, sure.
Okay.
So I can go. If you wanted me to look through the ones that aren't on here, and here it just adds it. 350, 10, 350, 105, 11, I think it is.
On the Met Towers, there's a special use permit, so special use permits go through the planning board.
That's subject to review and approval or denial.
Every year.
Right.
So
And
you got basically every year you can deny it if you don't comply.
Sorry, George.
That, I don't think there's anything here, but restoration, the applicant, I'm assuming that's the heritage or whoever's coming in, and its successors, heirs or assigns, I don't know if a company can have heirs, but are responsible for restoration and all costs associated with restoring the project site. Ground disturbance must be minimized to the extent practical, and the site restored to its original condition to the extent practical, and reestablish using native seed mix or any agricultural areas. Coordination with the landowner to allow desired crops to be replanted. Roads may be adequately restored to the original condition or better, following decommissioning activities, access roads and residential minor improvements may remain with the written consent of the landowner. Roads may be, that's after decommissioning. Is there anything in here for them to take care of our roads after they get done putting these up?
There's gonna be there has to be a highway use plan, and as part of that highway use plan, they have to, any damage they do, they have to fix
That's it.
along the way.
And where would we find that? Is that something the town takes care of? Is that something that the state
That's gonna be,
requires, or?
it will be part of the host community agreement. There's gonna be a highway plan, because they have to tell us specifically what roads they're gonna be using, what the weight of the vehicles, the parts, everything else, whether it can withstand that, and as I said, any damage that's done, they have to restore it, and not wait 20 or 30 years to do it.
Okay. Well, we're back to,
So, let's just
yes?
sum up here, which we're still on track here. I mean, do we need to make, maybe George is involved in this, that we use the minutes as our method of comment to the planning board? You in favor of that?
You wanna read them back, we can do a make sure they're all there.
Do we want?
I would prefer to write them up, and I can send them out.
Okay.
Okay.
The concept of using our minutes for comments to the planning board? We all agree?
And that gives us a chance to look at them in writing as well.
You want to make that a motion? I'd like to make that motion.
John wants to make a motion that
We use the minutes
we
as
use
our
the
comments.
minutes as our comments to pass to the town board
On the changes to the minutes.
as we see the changes to the wind ordinance.
After we review them from the.
Yeah,
Right, they're like normal minutes, we have to approve them later.
I'll second.
We have a second. In favor?
aye.
Aye.
Well, that makes our job easy. We don't need to make a summary.
Right. Um,
Are they doing the zoning, rezoning too for
I
next?
guess I'm still asking is when does the public have their say in a voice for?
because there's a
Or-
public
Not-
hearing.
They can be ignored from the public hearing. When can they actually have a say in how things go?
Explain, I'm curious about this, 'cause I want to know what's in your head. What is it that it takes to make someone or the public to have a say that we're not doing? Do you know what we are doing? Can you tell us, what should we add to what we're doing? Just your opinion, not that we would,
I would like to have,
you know what we are doing, you know what we are doing.
we are looking at the proposed wind changes to make to the board, so if they can make these proposed wind changes.
And once the town does this, you know the process here as far as public hearing.
The public comes in and they say yes or no, if they don't have any vote on it, it can be completely discredited. Yep, we heard you, okay, good.
Right. I mean, that's what a public
Here, yeah.
hearing is.
So what I'm saying is, when does the public have their actual say?
And what, explain yourself. What does it take to have their say?
A voice. I think they need to feel like I think the majority of these people, if this project was put before them and the majority of the town said, yes, it's a good thing, I think the majority would get behind it and say, okay, let's do it right. If the majority of the people say we don't want it, and yet it's still being pushed through, I think we're gonna have a lot of unhappy people.
We have not only a public hearing, but as I indicated before, there are several parties to this process in front of the siting commission, the siting board. You know, Clear Skies Over Barre is one group. There are a host of other groups that have applied and received party status, which means they can participate at every level of those the state process. This is not, way back in the beginning, one of the esteemed citizens of the town of Barre said, well, we should have a referendum on this. And I tried to explain that there's no authority in the law to conduct a referendum. And a referendum would not be binding, it wouldn't even be authorized. So we keep coming back to that over and over and over again. There's no doubt that the governor of the state of New York has said as a policy that they want to be 50% reliance on renewable energy by the year 2035. So, from the standpoint of, are we going to be able to sit here and say, no, we don't want it, and that be the end of the matter? That's not realistic. So the best thing, at least from my standpoint, I'm not speaking as a resident of town of Barre, but the best thing from my standpoint is to build into this enough safety features, enough consideration so that if this is approved by the siting commission, and I'm not saying it will or it won't, that at least we've covered all the bases.
Okay, so if we look at the safety things that we kind of came back with, and I think that, we can hang our hats on a lot of the I'm counting on that ice throw, because that's a definite safety issue. And I'm counting on someone finding the safety issues in this article academic and go from that. But they said it's 700 feet is, if we don't make it 700 feet, it's gonna kill the project. Where does the public have a say on that? And shouldn't we get more information or more so that they can make say, look, if we go to 700, they're gonna give us this. I think that's where it comes down to.
And my comment on it, just personal comment, not representing the board here or anybody, you can look at it very practically, or very pragmatically, if you want to put it that way. If the town board goes through and does what they think is best, being an elected board, representing the people, and if they don't represent the people, and these windmills come in and they don't get proper compensation, or the people don't think there's proper compensation, they won't be on the board anymore. But the windmills are already here.
Yes. And we have to live with that.
So to say, in the long run, to say it's by the vote, that's how they, ultimately, as citizens, that's how we speak, is by vote and by comment. But one person does not sway the whole board. They can't look at one person as being representative of the whole town, no matter how loud they speak.
Okay. That was my Pollyanna way of looking at things too, for 60 years. I want the town to have a say. And that's why I guess I did the survey also. I want to hear what the town says, and I did not know what the results were going to be. And when they are this far, to that side, I got to speak up for the town. I would love to have had 100%, but I don't know what more I could have done to get 100%. I don't know.
So we're gonna wait for the minutes before we make an official motion. Other than the motion is going to be that we're gonna use the minutes to pass on to the town.
Once it's approved, once the
Once
minutes
it's
are
approved, okay,
it will be passed on to the town.
very good.
That's part of the motion. Right?
That's part of the motion.
The only motion left is to adjourn.
Yep. I have a motion to
We're
adjourn.
gonna do the zoning.
What?
Next meeting?
Our next board meeting is this week.
I thought,
There's a motion to adjourn.
And a second.
I thought they were gonna consider that extension of the commercial district along.
You got another
No.
comment?
If,
Okay.
if I find something in here that was
Discussed during this meeting,
I
it
guess, bring it up to,
needs to be
It's still gotta be approved.
approved. Yep.
Review process, so, okay.
If it goes into the minutes, that's to be approved, as being part of the minutes. If you bring in something outside of this, it probably won't get approved.
right, no, but on this, if there's something that wasn't on here, that it is a
The
change.
commercial district.
That's what
Can I just, not on this, but
Yes.
there was another change in the zoning law that they were gonna expand the commercial district along the Route 98 corridor, right? So has that been looked at by the planning board?
It has been looked at by the planning board.
Oh, okay.
It's gone to the town board now.
Okay, all right, I'm just trying to make sure, that's all.
Yep,
Okay.
It's going through the process.
right.
So that's still at the town level?
I think there's a public hearing in it. 16.
You got, correct me, it got approved to go to the county?
No, it's
No.
not, it has to, because it's a change in, I'll let you speak for
It
that.
has to go to the town planning board first, then it comes back to the town, then it goes to the county planning board. So,
But to a public hearing, which order
well, it has
does
to
it?
have a public, before it goes to the county planning board, it goes through a public hearing, correct?
I think that's where we are right now,
Yeah,
Right.
okay.
is to get it.
The town board has it.
Yeah.
Okay, I'll speak again on the public's behalf. On the ones that we changed from R1 to agricultural resident, and the public hearing is coming up. it's gonna go right over people's heads. Should people be informed that have property in R1 that's gonna be affected, get a letter?
They are.
Yes! Thank you.
That's part of
And
the.
in
Part of
public
the-
hearing, I do a letter to the 500, or the residents within 500 feet
That own, that have R1.
that have property.
Thank you, thank you.
But that's consistent, that's
That's
consistent with.
That's
any-
consistent with,
Consistent
right.
with anyone, any public hearing.
The public hearing for the,
Okay, what is it?
Just run over that.
264 Biden, 214 Trump.
Correct.
Wow. It's not over until 2/7.
no.